What does it really mean when we talk about a court aiming for complete justice? It sounds profound, right? Like going beyond just the letter of the law.
It really does. And that idea, that pursuit, takes us right into some pretty unique constitutional territory, specifically in India and Bangladesh.
Exactly. We're talking about Article 142 of the Indian Constitution and Article 104 in Bangladesh.
That's right.
And that's our focus for this deep dive. We've looked at news reports, some really interesting legal analyses comparing how these things work, and of course, the articles themselves, plus key court cases.
Yeah, it's like peering under the hood, isn't it, to see how these top courts can operate.
So, our mission today is basically to unpack these complete justice powers. What do they mean? Where did they come from? Why are they sometimes controversial?
And what do they mean for the balance of power, between courts, legislatures, and for individual rights, too? It's a big topic.
Okay, let's get right into it. This idea of complete justice. Fundamentally, what is it?
Well, both Article 142 in India and Article 104 in Bangladesh give their Supreme Courts this inherent power, a discretionary power.
Discretionary.
Yeah, to make orders needed for complete justice in a case it's already in front of them.
And they don't actually define complete justice in the constitutions.
No, they don't. And the general thinking is that this is deliberate. It allows for flexibility.
Right, so the courts can adapt to new situations, things maybe nobody foresaw when the laws were written.
Precisely. But it's not limitless. It's seen as a residual power.
Residual, meaning?
Meaning it's kind of a backup. It comes into play when the existing laws or procedures, well, they just fall short of delivering what the court sees as a just outcome in that specific case.
So it adds to the law rather than
Yeah.
just replacing it.
Exactly. It supplements, it doesn't supplant. That's the idea.
Okay, I think I get that. It's like a safety valve.
That's a good way to put it.
Yeah.
And historically, you can see a clear link to the English idea of equity, justice, and good conscience.
The old Court of Chancery stuff.
Yeah, exactly. Where equity stepped in because the common law was sometimes too rigid, too formalistic to achieve fairness in a specific situation. These articles do something similar for the apex courts.
Okay, so it's about fairness, correcting the strict application of law.
It is, but it's important to be specific about the kind of justice. The Indian Supreme Court, for instance, has made it clear that under Article 142, we're talking mainly about judicial justice or legal justice.
Not, say, broad social or economic justice.
Generally, no. That's more the domain of the Constitution's preamble or directive principles. This power is usually focused on fixing issues within the legal process itself for the case at hand.
Like what kind of issues?
Well, Justice Gajendra Gadkar mentioned things like making sure the right parties are involved, or maybe allowing new evidence if it's crucial, or even sending a case back down if that's needed for a fair outcome under the existing laws.
Okay, so ensuring the process itself is just in that specific instance. Let's dig a bit deeper into the origins. We mentioned equity.
Right. Think back even to Aristotle. He talked about equity-correcting law, where it's defective because of its generality. Laws have to be general, but life throws up specifics they might not perfectly cover.
And equity was the mechanism to handle those specifics.
Exactly. And Maitland, the legal historian, had that great line, equity came not to destroy the law, but to fulfill it.
Fulfill it. I like that.
So these constitutional articles are kind of embedding that principle, recognizing the need for this ultimate safety net when the standard legal tools aren't quite enough.
It's an inherent power, you said, but also residual.
Yes, it's inherent in the apex court, but it's activated residually when other provisions don't quite get the job done in a unique situation. It supplements the court's main powers. It doesn't override them wholesale.
Which gives the courts a lot of leeway, right? Discretionary justice, you called it.
It does. And that makes it really hard to create, a strict rule book for it.
Because you'd lose the flexibility.
Precisely. Trying to list every possible scenario would defeat the purpose. There's an old English case, the Earl of Oxford's case, that basically said human actions are too varied for any general law to cover everything perfectly.
Makes sense.
And the Indian Supreme Court itself said something similar in the Skipper construction case. Keeping the power somewhat elastic and undefined is actually part of its strength. Plus, the fact it rests only with the highest court is a kind of built-in check.
Right, there's an implicit trust there. Okay, so how has the Indian Supreme Court actually used Article 142 over the years? Has it always been the same approach?
Not really, no. Initially, the court was quite cautious. In the Prem Chand Garg case back in '63, they were very clear. Article 142 couldn't be used to make orders that clashed with fundamental rights or existing statutes.
So very much working within the established framework.
Absolutely. The emphasis was on consistency. That case involved a court rule about security deposits, and they tried carefully.
But that changed.
It did. Starting around the late 80s, maybe 1989 onwards, we saw a shift towards a much more expansive interpretation.
Expansive how?
A key case was Delhi Judicial Service Association. The court basically said that this power under 142 was special, constitutional, and ordinary laws made by Parliament couldn't limit it.
Wow, that's a big statement.
It was. That case dealt with issues around judicial officers being detained, so the court was asserting its power to protect the judiciary itself using 142.
What prompted this shift, do you think?
Well, maybe a growing sense that existing laws weren't always keeping pace with complex modern problems. Perhaps a greater willingness by the court to step in where they felt justice wasn't being served adequately.
And then came the Bhopal gas case.
Yes, the Union Carbide case. That was huge. A terrible tragedy, completely unprecedented. And the court controversially used Article 142 to push through a settlement, even suggesting it could override existing laws if there wasn't an explicit ban, to achieve what it saw as complete justice.
That must have caused a stir, overriding laws enacted by Parliament.
Oh, definitely. It sparked a massive debate about judicial overreach. Now, the court did say you have to consider laws based on public policy, but the assertion of the power itself was, well, striking.
Did that very broad view continue?
For a while. There was the Vinay Chandra Mishra case, where the court even seemed to claim power over Bar Council rules, though that specific point got overturned later.
So a course correction happened.
Yes, somewhat. The Supreme Court Bar Association case was important. It reaffirmed the power is extraordinary, but stressed it should supplement, not supplant, statutory law, kind of pulling back a bit from the most extreme interpretations.
But the overall trend remained more expansive than in the early days?
Generally, yes. Cases like Delhi Electric Supply and Academy of Nutrition Improvement show the court is still willing to use 142 quite broadly, even after that caution.
So it's this ongoing balancing act. Given that, have any clear guidelines emerged on when to use Article 142?
Yes. The court has laid down some ground rules. First, obviously there has to be a case pending before the Supreme Court. They can't just initiate something out of the blue using 142.
Okay, it needs a trigger.
Right. And second, the order must be necessary for doing complete justice in that specific case.
Necessary. That seems key. Any others?
Definitely. A big one is that it should be used sparingly. Only when other legal remedies, statutory ones, are either missing or just not adequate.
So it's not a first resort.
Absolutely not.
Right.
Cases like Laxmitas Morarji and the SC Bar Association case really hammer this home. You don't use 142 just to bypass the normal legal process.
And it shouldn't unfairly benefit one side.
Correct. The Fatso Asensthan case made that point. Complete justice has to be balanced. You can't just ignore statutory provisions to help one party over another.
And crucially,
it shouldn't be used to just ignore someone's statutory rights or blow past time limits set by law or act directly against what a statute clearly says. The A.B. Bhaskar Rao case is a good example there.
so these guidelines seem aimed at keeping it as that special, exceptional tool. Now, let's shift focus to Bangladesh. Article 104. How does it compare?
It's very similar in spirit and function. Article 104 empowers the appellate division, that's their top court level, to issue directions, orders, decrees, or writs needed for complete justice in any case before it.
Directions, orders, decrees, or writs. A bit more explicit, perhaps?
Slightly, yeah. It explicitly mentions directions and writs, making the scope seem quite comparable to India's Article 142.
And definition of complete justice.
Same situation as India. No definition in the Constitution, again, presumably for flexibility. And like India, the power only applies to matters already pending before the court.
But only the appellate division, you said, not the high court division.
That's right. In Bangladesh, the specific power resides only with the appellate division, which handles appeals under Article 103.
And how does the Bangladeshi Supreme Court view this power?
They see it as a vital tool against gross injustice, especially when existing law seems inadequate. The Razil Hassan case described it that way.
So, again, the core idea is very much aligned, stepping in when the normal rules aren't enough. What about the actual decisions in Bangladesh? Do the trends mirror India's?
There are definitely similarities, but maybe some nuances. Like India, the Bangladeshi court acknowledges complete justice isn't easily defined. The Nazrin Banu case mentioned it could involve law, fairness, equity, Common sense depends on the facts.
So that flexibility is recognized there too.
Yes. And they also caution against using it too often. The Abdul Qadir Mullah case stressed it's for when existing law is insufficient. And again, Abdul Malik Mullah confirmed it's only for cases pending on appeal.
The pending case rule seems universal.
It does. The Jamuna television case is quite instructive too. It confirmed the power is wide, inherent, supplementary, but cannot override statutes, and complete justice defies definition. So very similar contours to the Indian position.
What about limitations? Fundamental rights?
Same constraints apply. Can't violate fundamental rights, can't disregard express substantive law. Cases like the Fadar Marfat Ali Shah and H.M. Rashad make that clear.
Okay. So, while powerful, it operates within constitutional limits. Can you give some examples of how Bangladesh has used Article 104?
Sure. It's been used quite diversely. To ensure fair property distribution, Habib Rahman, protect freedom fighter rights, and NCN Yusuf Ali, fix an unfair seniority issue, Raziul Hassan.
So individual justice issues.
Yes, but also broader things. Environmental justice, like in the BL case, directing cleanup measures, upholding civic rights in that Jamuna television case we mentioned.
Interesting. Even reducing sentences.
Yes, even that. In exceptional cases where there wasn't a specific law allowing it, cases like Mehdi Hassan and the Blast case show that.
Wow, that's quite something.
It is. They've also used it to cut short proceedings, avoid more legal loops, AFM Najarud Gandhisons, and for corrective justice, fixing clear errors by lower courts, Mohammed Nawaz, Ekoshe Television.
It really highlights the potential reach of such a provision, but with great power. Well, what about misuse or maybe underuse?
Absolutely a concern. In India, the Bhopal settlement under Article 142 remains a classic example cited by critics as potential overreach, especially the quashing of criminal cases.
And the broader judicial activism concerns.
Exactly. Some commentators worry about judicial adventurism. The courts may be stepping into legislative or executive shoes. Using 142 to grant divorces on grounds not in the Hindu Marriage Act is another area that draws debate.
The fear being the judiciary becomes lawmaker.
That's the crux of the concern for some critics. But conversely, you also hear arguments that sometimes the court doesn't use 142 when perhaps it should have.
Like when?
Well, some might point to A.B. Bhaskar Rao, where relief wasn't granted, or the reluctance in cases like Vishnu Dutt Sharma to grant divorce for irretrievable breakdown, saying he was up to Parliament. Some argue that in those cases maybe 142 could have provided a just outcome.
So it cuts both ways, damned if you do, damned if you don't, perhaps. Looking at both countries, what are the main similarities and differences then?
The big similarity is the core concept. An extraordinary residual power to prevent injustice, uphold rights, used judiciously, respecting fundamental rights and substantive laws. Both courts can fill legal gaps.
And the differences?
I think a key difference is how much formal guidance has developed. The Indian Supreme Court has, through its rulings, built up a more detailed set of conditions for using 142, considering statutory bars, manifest injustice, etc.
Whereas in Bangladesh?
While the Bangladeshi Supreme Court has laid down principles in its cases, it hasn't perhaps articulated such a comprehensive framework or set of guidelines as India has. This might mean a bit less predictability in how Article 104 gets applied there.
That's an interesting distinction. Clearer guidelines potentially leading to more consistency. Now, you mentioned divorce in India. Let's focus on that specifically irretrievable breakdown of marriage in Article 142.
Yes, this is a really active area. The Supreme Court has increasingly used Article 142 to grant divorce on the grounds of irretrievable breakdown, even if one spouse objects.
Even without consent?
Yes. Cases like Shilpa Shailesh and Dr. Nirmal Singh Panesar are key examples. The reasoning is, if the marriage is utterly finished, emotionally dead, beyond saving, the court can use 142 to grant dissolution, even though irretrievable breakdown isn't a specific ground in the Hindu Marriage Act itself.
What sort of things does the court look at in deciding that?
They look at, well, how long the couple has been separated, how long they lived together before that, the kind of accusations flying back and forth in court, any previous orders. Have they really tried to settle things? A long separation, say 6 years or more, is often seen as a strong indicator.
And it can speed things up, too.
Yes. The court has also used 142 to waive the mandatory 6-month cooling-off period for divorce by mutual consent if they're satisfied the breakdown is truly irretrievable. Amardeep Singh and Amit Kumar were earlier cases touching on this, referenced in Shilpa Shailesh.
Can it clear up related legal messes, too?
It can. The court might use the power to quash related proceedings, maybe even criminal cases like harassment claims, if there's a full and final settlement between the parties.
But people can't just file a writ petition asking for divorce based on breakdown.
No, absolutely not. The court has been clear on that. You still have to go through the normal divorce procedures first. Article 142 is a power the Supreme Court uses in cases that reach it through the proper channels, not a shortcut for litigants.
Got it. So it's a tool for the court in specific circumstances, not a new pathway for everyone. Okay, let's loop back to that potential for overreach. The source Practice asked, does 142 let the Supreme Court effectively take over from the executive or legislature?
That's the big question, isn't it? And the examples often brought up are things like the Union Carbide settlement again, the coal block allocation cancellations, the highway liquor ban.
Actions with massive policy implications.
Exactly. Those are seen by some as the court stepping deep into policy territory.
But the flip side, when is it seen as positive?
The counter-arguments usually highlight cases where the court stepped in to protect fundamental rights when, arguably, other branches weren't acting. The Vishaka Guidelines on Workplace Sexual Harassment are a classic example. The court filled a legislative vacuum.
Right, no law existed, so the court laid down rules.
Precisely. Or the Bankua Mukti Morcha case on bonded labor, or Olga Tellis on the right to livelihood for pavement dwellers. These are seen as vital interventions upholding constitutional values. Article 142 can be crucial for filling those gaps.
So it's this constant tension, a necessary tool, but one that needs careful handling.
Exactly. Critics worry about accountability. Was the e-rickshaw ban in Delhi fully thought through in terms of impact? Did canceling all coal blocks treat every case fairly? The fear is that too much intervention might undermine faith in government institutions.
Finding that balance.
It's crucial. As some court observations suggest, like in the Supreme Court versus the Union of India case, the power needs to remain curative, focused on justice in the case, and not become a way for the court to effectively run the executive or legislate from the bench.
This has been incredibly illuminating, really getting into the nuts and bolts of these powerful articles. To wrap things up, what are the main takeaways for our listener?
I think the core takeaway is that Article 142 in India and Article 104 in Bangladesh are truly significant constitutional powers. They equip the highest courts with a tool to achieve complete justice when normal laws fall short. But they are extraordinary residual powers.
Meant for specific, compelling situations.
Right, and they're subject to scrutiny and debate.
And the fundamental tension we keep coming back to.
It's that balance between the need for such a power to handle unique injustices and fill gaps, and the very real risk of judicial overreach or inconsistent application. It's about protecting rights without upsetting the fundamental balance of powers in a democracy.
So maybe a final thought for you, the listener, to chew on. Thinking about all these examples, the successes, the controversies, when do you think it's truly justified for an apex court to use these kinds of extraordinary powers? And what safeguards are really needed to keep that balance right, protecting both individual rights and the structure of government? It's a question that's far from settled.